Hello, my name is Karin Ablin, and I'm a partner at the law firm of Fletcher Heald Hildreth. Our firm's practice focuses on representing media and telecommunications companies. My practice in particular focuses on assisting media and other companies with music licensing and other copyright law issues that may arise in their businesses. This video is part of a series of videos prepared for women in media to highlight issues that lawyers embarking on their legal careers may encounter as they provide legal advice to media companies. Today, I'm going to talk to you about how to approach content licensing questions. Media companies not only create their own content, but also often use content created by others that typically is protected under US copyright law. Unless a company is sure that third-party content does not require a license, it needs to make sure that it's obtained the permissions that it needs before using that content. When faced with a content licensing issue, the first question to ask yourself is whether the content that you would like to use is protected by US copyright law. Copyright law protects works of authorship that are original, meaning that they exhibit some level of creativity. Those works also must be fixed in a tangible medium of expression that is sufficiently permanent or stable to permit the work to be perceived, reproduced, or communicated for a period of more than transitory duration. A wide range of works qualify for copyright protection. Some works that media companies may use are literary works such as news articles, pictorial works such as photographs, audiovisual works such as TV news clips, and for recorded music, which embodies two types of copyrighted works, they use both musical works, which are the notes and lyrics to a song, and sound recordings, which consist of a specific recorded performance of a particular song. A complete list of works eligible for copyright protection can be found in Section 102 of the Copyright Act. Once you've identified the works that you would like to use, you need to identify the types of rights that you need to obtain. Copyright law grants a bundle of exclusive rights to the copyright owner, including the right to publicly perform a work, to make copies of that work, to make derivative works of that work, which is a work that itself incorporates content of a pre-existing work, and to publicly display the work. You generally need to obtain a license if your use encompasses one or more of these rights. Once you've identified the works that you'd like to use and the rights that you need to use them, determine whether those works are protected by copyright. For example, that their protection is not expired and that they're not available to use on a royalty-free basis. Then create a matrix that lists the works across the top and the rights that you need down the left-hand side. You will need to check each box to make sure that you have obtained the relevant permission to the use of the specific work for the specific right in question. The above matrix considers the rights that a radio station might need to perform and podcast music, for example. Finally, when considering licenses for content created by others, consider whether that content itself includes content created and owned by yet another party. If so, consider whether you need to obtain a license from that other party as well. I trust that you found this video helpful as you develop your media law practice. If you need more specific legal advice about a particular situation, feel free to contact me at ablin@fhhlaw.com or 703-812-0443. Thank you and best wishes in your practice.